Welcome to this webinar sponsored by the George Washington University Law School's Government Procurement Law Program on the Supreme Court's landmark decision in Loper Bright Enterprises v. Raimondo, issued on June 28, 2024. My name is Chris Yukins. I serve as the Lynn David Research Professor in Government Procurement Law at GW Law School. As I noted in the chat already, the recording materials from today's session are available on publicprocurementinternational.com. The actual link is included there in the chat, and the recording will be available on the GW Law Government Procurement Law Program YouTube page as well. That'll occur over the next 24 hours. We have audience questions and answers. We also have chat if you'd like to ask questions in chat. The public chat will be part of the recording of this proceedings. That'll be posted on Public Procurement International as well. I want to emphasize that because several of the speakers are advocates as well, the speaker statements are in their personal capacities alone. There's a background discussion paper that talks about both the Loper Bright Enterprises case and other cases. It's available on publicprocurementinternational.com on the page dedicated to this program. I'm going to give some introductions in just a minute. We're going to have three separate presentations. The first one's going to be from Joshua Schwartz, Professor Joshua Schwartz from GW Law. He's going to discuss the decisions in Skidmore, Chevron, and Kaiser, and touch on the major questions doctrine. Nicole Williamson from Arnold & Porter is going to be talking about major government contracts decisions under the Chevron decision that was overruled by the court in Loper Bright Enterprises. I'm going to join her and talk about Percipient.ai, which is a major recent decision in the Federal Circuit, bid protest decision, and ask whether or not that, in fact, is the first post-Chevron decision, ironically issued just a few weeks before Loper Bright Enterprises, whether or not it's a template for future cases. Nathan Castellano of Jenner & Block will be talking about the Loper Bright Enterprises case in detail. Then we'll have panel discussion and questions from the audience as well. We're going to try to wrap up in about an hour. So going through our panelists, I'd like to introduce our very distinguished panelists for this session. Professor Joshua Schwartz is the E.K. Gubin Professor of Government Contracts Law at GW Law School. Professor Schwartz joined the law faculty in 1985 after serving for 5 years in the Office of the Solicitor General in the Department of Justice, where he was responsible for briefing and arguing cases before the Supreme Court. And he was involved, as he'll discuss, in the Chevron case while at Justice. In addition to his law degree, Professor Schwartz holds a master's degree in city and regional planning. He served as a law clerk for Judge Marvin E. Frankel of the U.S. District Court for the Southern District of New York. Thereafter, he served for 2 years in the appellate section of the Environment and Natural Resources Division of the Department of Justice. Professor Schwartz teaches and writes in the fields of property, administrative law, government contracts, and legislation, and he's a regular participant in domestic and international conferences on public procurement issues, including comparative public procurement studies. Nicole Williamson is an associate in the Government Contracts and National Security Practice Group at Arnold & Porter. Nicole recently rejoined A&P after finishing a clerkship for the Honorable Sharon Prost of the U.S. Court of Appeals for the Federal Circuit. So she has recent experience in the Federal Circuit. She previously clerked for the Honorable Richard Hertling of the U.S. Court of Federal Claims. Nicole received her law degree from Harvard Law School and her BA in political science from Washington University in St. Louis. During law school, Nicole served as a legal intern for NASA, where she gained firsthand experience in procurement and administrative law. Nathan Castellano is special counsel in the Government Contracts Practice Group at Jenner & Block. He graduated from GW Law School as a Murray Schooner Procurement Scholar in 2015. Last year, Nathan joined Ralph Nash and me as a co-author on the 5th edition of the Formation of Government Contracts Treatise. And Nathan is a contributing author, along with Vern Edwards, to the Nash and Sabinek Report. Nathan previously clerked for the Honorable Jimmy Reyna at the United States Court of Appeals for the Federal Circuit. He interned for the Honorable Mary Ellen Costa Williams at the United States Court of Federal Claims, and he worked as a legal consultant to Pascal Dubois, the World Bank Office of Suspension and Debarment. And just a quick note on our audience. In our audience, we have audience members from 14 countries around the world, and in the United States, we have folks registered for the program who come from 33 of the 50 states in the District of Columbia. With that, I'll go ahead and turn it over to Joshua. Josh, you're still on mute.
Thank you, Chris. Okay, good morning, everyone. Thank you for joining us for this webinar. It's an exploration. It's intended to be an exploration of the Supreme Court's recent decision in Loper Bright, which you've heard. And importantly, from my point of view, and maybe everyone's point of view, is that Loper Bright says, at least, that it overrules the 40-year-old Supreme Court decision in Chevron versus NRDC, which is a case I think many of you will know about, even if it's not your practice area. It is literally the most cited federal court decision of all time, more than Marbury versus Madison, if you can believe that. So it's something you ought to know about. And since Loper Bright says the law is not Chevron, I guess you need to know something about what Chevron says. The other thing you ought to know, which many people in the administrative law community would know, but many people in the government contracts community may not, is, as Chris says, I was there at the inception. I'm the old guy in the room. In 1983 or 84, in the run-up to Chevron, I was the assistant to the Solicitor General who wrote a memo about that case. I was the one who wrote the government cert petition in that case. I did not handle it on the merits or argue it. Basically, what I'm about to say probably once was a government confidence, but it's been leaked for 40 years now by other people. So I think there's no confidential value in it. The memo I wrote said that the government should not petition in this case and that it would and ought to lose. As Nathan said to me just before we got started, in a certain sense, I've now been vindicated just 40 years late. Anyway, we did petition. It was shooting fish in the barrel to get cert granted. Chevron had also already filed a cert petition. One cute fun fact that you all ought to know that maybe is of no legal relevance is that EPA was going through a series of scandals at the time, and there was an acting administrator which changed day by day. One day before we filed the cert petition, the acting administration was a woman named Ann Burford. And what you need to know about Ann Burford is that before she divorced and remarried, she was Ann Gorsuch. Yes, she's Justice Gorsuch's mother. And of course, you may also know that Justice Gorsuch for many years has been famous for being the most vigorous advocate for overruling Chevron. There's a Freudian thing in there somewhere. I just don't undertake to explain it to you. The dominant, I've been following the administrative law lists on this subject about what Loper Bright did to Chevron. They're not focused on the government contract situation specifically, which is basically why we collectively are here. But the dominant view, it's not the only view, the dominant view is that it's all much ado about nothing because the Supreme Court says it's overruled Chevron, but nothing will change. In brief, that would be that those who like to defer to agencies will still defer. They'll just use different language and different citations. And those who don't like to defer to agencies will not defer. And there's a lot of that going around, particularly in the Fifth Circuit. So it's possible that Loper Bright actually makes no difference whatsoever, but we're going to at least examine the possibility that it does. The next thing I need to introduce you to is something that Justice Kagan, who dissented in Loper Bright, might call the Chevron problem. She says that before Chevron and during Chevron and after Chevron, that's now, there's always been and always will be necessarily a Chevron problem. Whether or not there's a Chevron doctrine, there's a Chevron problem. And she cites cases from the 1940s in particular, NLRB versus Hearst, which when I got started in teaching was taught in every administrative law class, and Gray versus Powell from the Supreme Court in 1941, which applied a kind of deference which many people think is indistinguishable from Chevron. I used to say a little bit flip that Chevron had to be understood as the second coming of Hearst and that it actually did nothing new. It's also worth knowing that it was always Justice Stevens' view, Justice Stevens wrote Chevron, that Chevron did nothing new. I've now got this corroborated from 3 separate sources, and I might as well briefly mention, like important cases, Chevron came down at the end of a Supreme Court term. And right after the end of that term, there was a major law conference, administrative law conference at the Columbia Law School. And Justice Stevens was invited, and Professor Peter Strauss, an eminent scholar in the area, now retired, was there. And he walks up to Justice Stevens, and I have this from Peter Strauss's mouth, not Justice Stevens, but wait. And Peter says to the justice, that's a very important and revolutionary decision you rendered. And Justice Stevens first affects to not even know what he's talking about, because I didn't do anything, nothing going on here, nothing to see here. And then he said, this was meant to be a restatement of existing law. He said the same thing to Dan Farber, a longtime law professor who was his law clerk. And he said the same thing to Sam Estreicher, a longtime law professor at NYU, who did an oral history of this stuff. And in each case, he said, we didn't mean to do anything new. So if overruling Chevron means returning to the law before Chevron, possibly the law before Chevron was meant to be the same as the law after Chevron. The reason there's a Chevron problem, whether you like the doctrine or not, is that Congress frequently passes statutes that contain ambiguities and gaps. I'm tempted to say, but it's indecorous, duh. I mean, it's hard to see how any lawyer could doubt that proposition. He or she, you make your money by dealing with such things. The majority in Loper Bright doesn't quite acknowledge this, but it certainly doesn't deny it, and it tacitly accepts it no matter what. So there's a problem about what you're going to do when the statute is not clear on the question that an agency needs to solve. And roughly speaking, as the court says in Loper Bright, you could either defer to what the agency thinks about the gaps, or you could have the court decide it independently. But as I've said, there's a long time history of deferring to agencies before there was a Chevron doctrine. And even Loper Bright says, well, we're not saying we won't give them a lot of respect. Respect is the new deference. It's like orange is the new black. Respect is the new deference. You can't call it Chevron, but that doesn't mean you aren't doing the same thing. I'm expecting that most of you are familiar with what's usually described as the two-step Chevron test. Can we go to that slide, Chris? Yeah, we're skipping Skidmore for a reason. We'll come back. Although Chevron is described by Chevron as a two-step test, almost everyone, including Loper Bright, will describe it as either a 3 or a 4-step test. And since lawyers are presumed to be anumeric, and we need a number lower than step 1, this has been christened as step 0. Even Loper Bright accepts that. And at least most scholars accept that step 0 has 2 parts, because lawyers don't do negative numbers, so we can't have a step -1 in front of step 0. So step 0 has part A and part B. Okay, the basic idea is that Chevron only applies when a statute is to be applied only by one particular agency. There's some wrinkles in that, but they don't much matter for our purposes. Notice that this is very important in government contracts world, because most of our statutes, whether you're talking about the APA or FOIA, but also the FPASA, apply to multiple agencies. No state agency gets deference on what to do with that statute, how to interpret that statute, because which one would you defer to? The only one who can plausibly claim deference is the FAR Council or some part of the operation that produces the FAR, which interprets those statutes. The Office of Federal Procurement Policy Act also comes into play there, but only agencies which can claim they uniquely have oversight over the whole shooting match can claim deference there. But may as well say this now, I'll say it again later. There's another way to get deference, which is when a statute expressly delegates authority to one or more agencies. And we actually have that with regard to the creation of the FAR. So deference to the FAR as an interpretation of the statutes that sit on top of it or underneath it does not depend on Chevron or Loper Bright, and I'm going to say may not be changed at all. So Chevron applies only when you have a statute that applies to a particular agency. Second, it applies only when you do the right kind of administrative proceeding. I'm going to mostly skip over that. That's third, the court, the reviewing court, is supposed to interpret the statute using, quote, all the traditional tools of statutory interpretation, which means if you're a textualist, do that. If you're not a textualist, do that. Use legislative history or not, but whatever you would do, you use all those tools. There's nothing special here. If after all that, the statute doesn't yield an answer, Chevron said you should treat that as a delegation to the agency to fill in the gaps as though it were an express delegation. Like EPA has tons of express delegations that say, you know, make regulations for the Clean Air Act, make regulations for the Clean Water Act. What Chevron rested on was that theory of implied delegation. And then finally, the last step of Chevron was, if you get to this step, and you may not because it's the wrong kind of proceeding or the wrong kind of statute, or it's a clear statute and there's no gap, but if it's the right kind of statute and the right kind of proceeding, and it's the statute really using all the traditional tools is not clear, then you defer to the agency and you uphold its decision the same way you would in any other delegation, express delegation, if it's reasonable. And reasonable means the same thing as arbitrary and capricious under the Administrative Procedure Act. Justice Stevens has also been asked why he didn't use the term arbitrary and capricious, the APA term, and instead he used the term reasonable. And basically the answer is no reason, they're synonyms. It took 20 years of working that out, that they're synonyms, but they're synonyms. So you'll notice that what Chevron does is says you apply the same approach to express delegations and to implied delegations. Because of this rule about Chevron only applies when you have a delegation to one agency, essentially that has to be true, because otherwise, are you going to defer to the Labor Department or the Commerce Department about the interpretation of the APA? What if they don't say the same thing? Okay, so easy examples. We defer to the NLRB, National Labor Relations Board, in interpreting the National Labor Relations Act, because that's a single agency express delegation. We defer to the EPA in interpreting the Clean Air or the Clean Water Act. Notice that Chevron probably doesn't really involve the APA at all. The court seems to miss that fact. We defer to the National Wildlife Service of the Interior Department in interpreting the Endangered Species Act. We don't defer to anyone in the interpretation of the APA. And probably the same thing is true for FOIA and any other generally applicable statute that if it applies to everyone, you defer to no one. So that's the situation that we were in under Chevron. And I'm about to run out of time, I suspect. But the key thing is that Chevron is the case about implicit delegations, and it's not the case about express delegations where the law hasn't really changed at all. The last thing I want to mention, and we can do some other things and you can ask questions later, there is in recent years, the last 4 or 5 years particularly, this thing called the major questions doctrine. And it turns out that there are 2 major questions doctrine. Most everyone agrees with that. One version of the major questions doctrine applies only as an exception to Chevron. And if Chevron is gone, then that's gone. But on the other hand, the other version, which is still, I think, very much alive, is that the major questions doctrine applies to say you need an unusually clear statement if a general statutory express delegation is being relied on to allow an agency to do something politically controversial. And the best example of that is the vaccine mandate or certain environmental regulations, which say phase out coal power entirely. If Congress wouldn't have delegated this, then the statute shouldn't be read as delegating it. But the statute's application of this doctrine, which was the original application under Chevron, I think is just a dead letter. There's no reason for it anymore. I think I ought to stop there because otherwise I'm infringing on my colleagues' time, and I'm happy to take your questions later.
Thanks
Chris.
very much, Joshua. With that, I'll turn it over to Nicole.
Great, thank you. And let me begin by saying I'm delighted to be among such esteemed panelists today. I'd like to start my discussion by discussing the framework under Chevron and how Chevron has been considered by courts in the past. And so there are a great number of cases that could be discussed here, but I'd like to just focus on a few representative examples here. And so as we just heard, the Federal Acquisition Regulation, the FAR, is the result of a 1979 statute, which directs the Office of Federal Procurement Policy within the Office of Management and Budget to issue policies for the purpose of promoting the development and implementation of a uniform procurement system. And so updates to the FAR are generally made by the Administrator of General Services, the Secretary of Defense, and the Administrator of NASA, acting on behalf of the Federal Acquisition Regulatory Council. And so like other regulations, FAR provisions are agency interpretations of the statutes that they implement, and courts generally review the FAR provisions in light of Chevron in considering whether the interpretations are entitled to deference. And so turning to this first case example here, Newport News Shipbuilding, this case involved the question of whether the contractor had properly certified its claim to the contracting officer. And so the ASBCA had granted the government's motion to dismiss for lack of jurisdiction for failure to certify the claim to the contracting officer under the Contract Disputes Act, Section 6C1, and the implementing regulation, which was FAR 33207C2, because the person who had signed the claim on behalf of the contractor was not authorized to do so. And the Federal Circuit in this case affirmed. The court explained that the CDA was silent on the individual who can certify a claim, and that left a gap. In that gap, FAR 33207C2 provided direction on who could certify the claim, and it filled the gap implicitly left by Congress respecting who could certify the claim. And so the court noted that the Office of Federal Procurement Policy had the statutory power under 41 USC 607H to issue guidelines for the functions of agency boards. And so I'll directly quote from the Federal Circuit here. The court told us that on its face, FAR 33207C2, which fills the gap that Congress implicitly left regarding who may certify under Section 6C1 of the CDA, is clearly within the congressionally delegated authority of the OFPP. Therefore, we must accord considerable weight to the agency's interpretation of a statute it is responsible to implement, end quote. And the court cited Chevron there. And so this case demonstrates that where the statute was silent on a particular issue, the FAR provision filled that gap implicitly left by Congress, and there the Federal Circuit deferred to the FAR provision. If we turn to the second bullet here, deference to SBA regulations, one example case is Palladium Partners, which was a 2015 Federal Circuit case. And there it was an NIH solicitation that was set aside for small businesses. And a prospective offeror challenged the NAICS code, the North American Industry Classification System code, for that particular procurement to the SBA. And the SBA Office of Hearings and Appeals considered the code and determined that the contracting officer should change the code for the procurement. Palladium then filed a suit at the Court of Federal Claims seeking to enjoin use of the new code without having participated in the SBA proceedings. And so here, SBA regulations provide that the appeal is an administrative remedy that must be exhausted before judicial review of a NAICS code designation may be sought in court. And Palladium had not done that. And so the court explained, and again, I'll quote from the Federal Circuit here, they said, whereas here, Congress has specifically delegated rulemaking authority to an agency, courts lack authority to undermine the regime established unless the regulation is arbitrary, capricious, or manifestly contrary to the statute. And so, at the end of the day, the court held that SBA's regulations require an interested party to participate in a pending OHA NAICS code appeal or be precluded from filing suit. So the bottom line is that this is another instance of deference here to the SBA's regulations regarding exhaustion. And so in the final bullet you'll see on the slide here, cost accounting, this is another area where we've seen deference in the past. And so specifically, cost allowability concerns whether a particular cost can be recovered from the government in whole or in part. And so allowability of a particular cost is governed by the cost principles, which are expressed in FAR Part 31. And so just as one example case, of course, there are several relevant cases here. In 2003, the Federal Circuit had a decision involving allowable costs. This was under a cost reimbursement contract, and the contractor was seeking fees it incurred in defending against criminal charges that were brought against its employee for fraud. And so here the employee was convicted of fraud, but the contractor was not. The contracting officer denied the claim for costs, and the board ruled in favor of the contractor on entitlement. And so on appeal to the Federal Circuit held that FAR 31.20547B defines the term contractor to include both the contractor and the contractor's employee. And it disallows costs incurred in the unsuccessful defense of criminal proceedings where an employee is convicted, even if the contractor is not. And so there, the Federal Circuit found that the statute 10 U.S.C. section 2324, as amended by the Major Fraud Act of 1988, was ambiguous. The statute did not expressly provide who may be convicted or who must be convicted for purposes of cost disallowance. And so having found the statute ambiguous, the court asked whether Congress has left an explicit or implicit gap to fill. And so it explained again that the FAR is the very type of regulation that the Supreme Court in Chevron has held should be afforded deference because Congress had specifically authorized the FAR. And so the court held that the regulations were a reasonable interpretation of the statute and held that that FAR provision, 31.20547B, was entitled to Chevron deference. And so I think these three cases just provide an example of how Chevron has worked in the past and how courts have tended to defer to the regulation. If we could turn to the next slide. So I'll just discuss three additional cases. As many of us in the government contracts community know, there are very few Supreme Court decisions in the government contracts world, but we have this case Kingdomware. It's a 2016 opinion authored by Justice Thomas. And this case shows a statutory interpretation where the court found the statute to be unambiguous and declined to defer to the agency here. And so by way of background, the Veterans Entrepreneurship and Small Business Development Act established a 3% government-wide goal for contracting with small disadvantaged veteran-owned small businesses. And so to reach that goal, a separate set-aside provision is known as the Rule of Two. It establishes that the contracting officer shall award contracts by restricting the competition to veteran-owned small businesses if the officer reasonably expects that there will be two such small businesses submitting offers and that the award can be made at a fair and reasonable price. And so in finalizing its regulations to implement the act, the VA had stated in a preamble that the statute in section 8127, those procedures did not apply to federal supply schedule, task, or delivery orders. And so in its decision, well, the court noted that Kingdomware had alleged that the VA had procured multiple contracts through the federal supply schedule without having restricted that competition using the Rule of Two as the statute required. And so Justice Thomas explained for the court that section 8127D had unambiguously required the VA to use the Rule of Two before contracting under competitive procedures. And the court said that there are no exceptions for orders for the federal supply system and that FSS orders are contracts. And so, as relevant for our purposes here in terms of deference, the court said, and again, I'll quote directly from the court, the department asked us to defer to its interpretation that FSS orders are not contracts, and the court then cited Chevron. Even assuming arguendo that the preamble to the agency's rulemaking could be owed Chevron deference, we do not defer to the agency when the statute is unambiguous. And so for the reasons already given, the text of section 8127D clearly imposes a mandatory duty. And then the court said, we decline the department's invitation to defer to its interpretation. So this is an example where the court did not defer. They found the statute unambiguous, and that was kind of the end of the day there. And turn to the next slide. Great, thank you. So this case, it has a little bit of a complicated history and legislative history here. But this is a case where the Federal Circuit interpreted the Randolph-Shepard Act. And so that's an act that provides blind persons with employment and economic opportunities by permitting them to operate vending stands in federal buildings. And so amendments to the act had given blind vendors a priority in operating new facilities and provided that any income from vending machines not operated by them was required to be shared with the blind vendors directly or with state agencies for the blind. And so the statute had contained an exception for that income sharing for retail sales vending machines in retail sales outlets under the control of exchange or ship store systems. And so the DoD had a regulation that interpreted the statute to mean that income from vending machines operated by or for the military exchange or ship store systems, those were exempt from the statute. And so here, I'll quote again the relevant language from the Federal Circuit. The Federal Circuit had looked at the ambiguities in the statutory language, the legislative history that supported the Department of Defense position, the purpose of the exemption, and the status of the military exchanges as non-appropriated fund instrumentalities performing essential government services. And so the Federal Circuit said, quote, "We are convinced that DoD's regulation is reasonable. It is not in conflict with the intent of Congress as expressed in the statute. For the foregoing reasons, we agree with the 10th Circuit that DoD's regulation is not void." And so this is a great case to examine in terms of the different tools of statutory interpretation and how the court had kind of come to that decision. And then I'll turn to the final case. Thank you. Okay, so finally we have this 2011 Federal Circuit decision in Allied Technology Group. And so this was a post-award bid protest brought by Allied of a Department of Justice award of a contract for an internet job listing website, which was awarded to Monster. And so there were a couple arguments at play here, but as relevant for us this morning, Allied had argued that Monster did not meet the requirements of Section 508 of the Rehabilitation Act. And so here, the Court of Federal Claims granted judgment on the administrative record to the government and to Monster as an intervener, and the Federal Circuit affirmed. And we'll focus on the majority, but really the Chevron aspect comes in the dissent. And so in the majority, Allied had argued that the contracting officer may not award the contract to an offeror who had failed to meet the requirements of the solicitation. And Allied had tried to show that Monster did not meet the requirements of Section 508 of the Rehabilitation Act. And so here the court agreed with Allied that compliance with Section 508 is mandatory, but because Monster had explicitly certified in its proposal that it was compliant with Section 508, including by submitting a signed certification, the court held that the contracting officer was entitled to rely on that certification in determining whether or not to accept the bid. And so the court really was emphasizing the deference to the contracting officer there. The dissent, which was by Judge Bryson, had a different opinion. The dissent emphasized that Congress had delegated rulemaking authority under Section 508 to the Architectural Transportation Barriers Compliance Board, which promulgated regulations that are known as the Electronic and Information Technology Accessibility Standards. And so essentially the dissent was saying there are regulations in place that specify exactly what the contractor was meant to do. And Monster had not really shown that it was compliant. And so to quote here the relevant language involving Chevron, Judge Bryson had said, although the majority characterizes the comparable access requirement of Section 508 as flexible, the regulations to which we owe deference under Chevron require specific modes of compliance, which were not met in Monster's proposal or in the contracting officer's response to that proposal. And so the dissent wanted to defer to the applicable regulations, but really, of course, the majority's opinion is what carries the day, and the majority had left the issue to the contracting officer's discretion. And so I think this case and the three cases showed different levels of deference and how these issues have played out in courts historically, all of which may be impacted a little bit by this new decision.
Thank you very, very much, Nicole. It's very interesting. Nicole was talking about the history of deference in the government contracts cases and understanding the difference between express delegation and implied delegation that Joshua went into. That division and the question of continuing deference, but as Joshua said, the word is no longer deference, the word is respect. How much respect the courts should show to agency interpretations. That's going to continue into Nathan's discussion in just a minute. I just very briefly wanted to touch on Percipient.ai. And Percipient.ai was a decision that came down early in June. And in the decision, the Federal Circuit found standing in Percipient, even though Percipient didn't actually bid on the contract at issue. So it was a bid protest where the plaintiff never actually bid. The Federal Circuit pointed to a statute which said that the prime contractor that won the IDIQ contract should, if at all possible, reach out for alternative commercial solutions in the marketplace. And the contractor didn't do that, and then Percipient bought his bid protest. The Federal Circuit also said the task order bar didn't apply because it wasn't really a task order being challenged. It was the overall way that the task order contract was being implemented. This case through June generated enormous controversy within the community. You sit in meetings of lawyers and they say, how do we read this? Does it rewrite standing to give subcontractors, prospective subcontractor standings? When could a bid protest be brought? Could it be brought at any point? How do we read this decision? There was a lot of confusion about the decision, which again was published on June. There's a very good, by the way, very good commentary on the decision that was published on June 24th by Jim McCullough and his colleagues at Fried Frank. That's in the government contractor. Well, that was on June 24th, but in then June 28th, the decision was issued in Loper Bright Enterprises. And you said, oh, holy cow, maybe Percipient is better understood against a tapestry of cases. And maybe it foretells for us what's going to happen in the future. What's going to happen under Loper Bright Enterprises as we enter this post-Chevron era. And interestingly, while a lot of the Chevron and Loper Bright Enterprises controversy has to do with conservative versus liberal judges, conservative versus liberal in the broader society, interestingly, the two judges in Percipient, those two judges were Obama administration appointees. They're not not conservatives. And yet they took a very aggressive approach to the existing case law, as Judge Clevenger pointed out in his dissent in Percipient.ai. And what we can begin to see here is that there are three separate elements, or three separate common elements in these cases that could be very important in the future as we understand future cases as well after Loper Bright Enterprises. First is there's a disturbing action in the administrative state. In this case, the Federal Circuit majority was very concerned about the fact that the agency hadn't ensured that the prime contractor reached out for what was, according to the pleadings, a readily available commercial solution. This is like in Kingdomware, where the Department of Veterans Affairs in Kingdomware was arguing against a preference for veterans. That seemed like a disturbing action in the administrative state. The decision is driven by a presumption that the statute of regulation is unambiguous. And if you look at, as Nicole explained, if you look at the Kingdomware case, that's a very aggressive assumption. But that assumption under Chevron, and now much more freedom after Loper Bright Enterprises, as Nathan's going to explain, the court can reach in and make its own interpretation of law. That's a very important part of that. That forceful reading of the law, as the courts take first authority for interpreting the law, that very forceful interpretation of the law can disrupt an existing architecture of the law, such as in Kingdom where the idea of task orders versus contracts being different things. So that seems to be an important third element of this as we think about cases after Loper Bright Enterprises. So Percipient.ai becomes not a confusing case, but an interesting way of thinking about the future after Loper Bright Enterprises. With that, I'll turn it over to Nathan.
Thank you, Chris. I'm going to comment on Percipient for just a moment. I've been hesitant to accept Chris's invitation to put these cases together. I think we could talk for a whole hour about Percipient without ever saying Chevron, but the idea's in my head now and I can't shake it. So there are, I think, sort of three parallels we can draw between them that help. The first is just like, why have we not seen Chevron cited in any of the Percipient decisions of the briefs? And I think the answer is, so far, the disputes in that case have been all about preliminary threshold issues of jurisdiction and interested party status and waiver. And those are the kinds of issues we never would have applied Chevron deference to in the first place. We wouldn't ask, how does the Chevron think we should interpret interested party in 1498? How does an agency think we should interpret the task order bar? Those are jurisdictional issues, and they're really not in the agency's territory to interpret. If you move to the merits of Percipient, I'm not sure Chevron really comes into play there either, because we have it's a very strong statutory mandate. Shall, to the maximum extent practicable, prioritize commercial and non-developmental items. I'm paraphrasing, but it's strong, broad language. You have a whole FAR Part 12 implementing it in detail with strong language. And I'm not sure this is a case where agencies are coming back saying, oh, we interpret FASA a little differently. We interpret FAR Part 12 a little differently. The response is more, hey, this is none of your business, and we have to have some room to decide how we manage this. And I'm not sure that's a case, that's an issue that changes with or without Chevron. I do think that without Chevron, we're going to have a lot more agencies in that position of being hauled into court, having to answer to statutory language that they've previously thought of as something they could handle on their own and is now going to be brought into courts. And the third point is just stare decisis. A lot of the Loper Bright opinion is about when is it appropriate for the Supreme Court to come in and officially overturn prior established precedent, as opposed to what we've seen over the past decade of just kind of ghosting the precedent and not citing it for 10 years. And what we're seeing, I think, right now in reaction to the Percipient decision, and I recommend reading Judge Solemson's recent contribution to the National Subventing Report, talking about the disruption and the discomfort that comes when the Federal Circuit sort of issues these piecemeal decisions, changing the statutory framework for jurisdiction and standing. That has its own, it's like they're kind of, the Federal Circuit right now seems to be sort of ghosting some of their prior precedent on standing and jurisdiction. And we have to wonder, is it finally time for them to go en banc and actually, put the tombstone on some of their prior cases? Or are we just going to see this piecemeal evolution that may work, but also leaves us as government contract lawyers in a very sort of uncomfortable place? And that's sort of where I think Percipient and Loper Bright might overlap. And moving on to Loper Bright, it's an interesting case of the actual background of the case about who's going to pay fees for having supervisors on herring fish boats. And Chris, I understand you have some connection to this from a...
Yeah, so I just, full disclosure, so my brother is actually a commercial fisherman in New England, and we had dinner again last night. Every single damn family dinner we have together, he complains about this inspection fee. It's a very big deal in the industry. And I told him, hey, Loper Bright said the inspection fee goes away. He was very, very, very happy because it's a big deal for the fishermen. They're paying for an inspector that, according to the Supreme Court, takes away 20% of their daily revenue.
So if you haven't heard, Loper Bright overturned Chevron. And the first thing I really want to focus on is the distinction between overturning Chevron on a constitutional basis under Article 3 and overturning Chevron based on the text of the APA. It's a 6-3 decision, really, of 6 justices voting to overturn Chevron. The majority opinion really does it. Everyone's invoking the idea at the outset, hey, Article 3, Marbury versus Madison, the judiciary is there to decide what the law is, to read the law and interpret it. The majority decision moves on from that pretty quickly and says, with that backdrop, Congress passes the APA, and the APA tells courts to decide issues of law. And Chevron deference is actually inconsistent with that language in the APA. If you read the concurring opinions, it's clear that there's also an argument out there that Chevron deference is just flat out unconstitutional. It's an abdication of the court's Article 3 duty to defer to an agency's interpretation of law. And I think this distinction, if it holds, could matter as we think about how this applies to government contracts cases, because a lot of government contracts law really exists outside of the APA. The APA rulemaking procedures actually expressly carve out issues of public contracts. The FAR is not promulgated under the APA rulemaking procedures. We have our own statute. It looks similar. They're borrowing from each other, but it's a different statute. We don't litigate bid protests and claims under the APA. We litigate them under different statutory frameworks, and we borrow the APA standards sometimes. So there's at least some room to think about whether or not, if Loper Bright really is tied to the text of the APA, does that necessarily apply to any given government contract issue? And I think the common theme going through all of this is, moving forward, we're just going to have to be much more thoughtful about understanding where each regulation comes from, what's the underlying statute, what does it say, and what are the implications from there. And I think we can start that with just this Article 3 APA distinction. The second point I want to discuss, I think, Chris, this is the when do we defer slide. So as I think this is Professor Schwartz was teeing up the idea that the Chevron problem, sometimes you're going to have an ambiguity, you're going to have a hole in the statute, and there's no getting around it, and you have to decide who's going to decide. When, if ever, would you defer to an agency? And in Loper Bright, you get some lip service to, well, sometimes the agency will persuade us. Sometimes they'll have special expertise. Sometimes maybe they were there when the statute was written and they've kept to the same interpretation since then, and it's just persuasive. Chris, we might be one slide back. I'm looking for that Loper delegation language. Not there. Maybe forward. There we go. So this last bullet, I think, has, and this isn't really just me thinking, this is something Professor Schwartz said while we were preparing. It turns out there's articles about this, and it's, I didn't just make this up. But in this last bullet, we've got a quote here from Loper Bright where it looks like it's an escape valve to invite back in some deference. And I'm not going to quote it, but the idea is that, if it's the court's job to interpret the statute, and sometimes the best meaning of the statute is that Congress delegated the issue to the agency. And if you find that the meaning of the statute is that Congress wanted the agency to decide, it might end up just asking if the agency made a reasonable decision. And that might end up looking a lot like Chevron deference. And you could go from saying, instead of Chevron deference, we'll just call it Loper delegation, sort of move around it. And a lot of the underlying government contract statutes, I think you could fairly read them as actually giving that delegation. And we may end up in a situation where there really isn't that much of a loss from Chevron deference. There are two areas I want to just flag as potentially up for that might, we've spoken a lot about how, hey, maybe this doesn't impact government contracts law a lot. I think there are some places that are up for rethinking. One is, there is a line of the cost accounting rules that Nicole flagged where it's really questionable whether the rules on allowability of certain costs relating to legal proceedings are allowable. Does the FAR rule follow the underlying statute? The Federal Circuit has deferred to the FAR's position invoking Chevron. I think we really have a question there of, is that still true? And that's, that's one example. Karen Manos has written a lot about it, so it's sort of already out there. But I think as we really peel back the onion and start looking at where do all these FAR rules derive from, where has the FAR Council maybe taken some liberties, we may find other principles and other provisions just one by one that are sort of open for question. This is on this list of ideas of, here important issues of procurement law that might be up for question, one that we don't have listed on here, is just the patent ambiguity rule. Right? We defer to agency interpretations all the time. We have government contracts written by the government, full of regulatory terms written by the government. Normally, under contra preferendum, those terms would be interpreted against the government. But we have a rule that just draws a line. If the contractor doesn't complain before the contract is formed, we'll defer to any reasonable interpretation the government can come up with. I'm not sure that's overturned by Loper Bright, but I think this is enough to sort of make us perhaps question whether the patent ambiguity doctrine makes sense. Just a few other points for us sort of open this up. A lot of these, to figure out the impact of this, I think we're going to have to look beyond the federal circuit. The federal circuit is going to decide protests, claims, a lot of important issues, but the real, like the big rulemakings, COVID mandates, GHG rules, that litigation is likely going to play out in district court outside of federal circuit. And we're going to have the issues that Professor Schwartz was talking about of, is this a major questions doctrine issue? Is there room in the statute to permit these massive regulatory frameworks, or is this going to be sort of the end of whole new compliance regimes plugged in through government contracts? And on that point, it's easy to say, we often say the federal circuit is our Supreme Court, and that's true in many ways. It's true if a client, just lost to the federal circuit and wants to go to the Supreme Court, it is a good way to remind them that empirically speaking, they're probably not going to review your protest or your claim. If the federal circuit issues a sloppy decision or has some stray language in a footnote, and you want to emphasize the impact of that, it's good to remind that Supreme Court really isn't going to weigh in here, and that footnote is going to be the last word. But we can't let that be an excuse to not watch what's happening in the Supreme Court, watch what's happening in other circuits, because they're issuing decisions every year that do impact government contracting, and we can't just be laser focused on the federal circuit. Just sort of, this all just comes down to just good lawyering of keeping your eyes on all the different dockets that matter. And speaking of good lawyering, I think between Kaiser, Loper Bright, this focus on statutory interpretation and regulatory interpretation, it really sort of raised the premium on mastering the tools of interpretation. Right? This is all just things that we assume good lawyers know how to do, but you really have to train to do them. You got to, read Sutherland statutory construction, read Scalia and Garner reading law, right? Like there are rules written down that we have to follow. And I think in recent years, mastering those rules is going to look more and more like what we have to do to be good lawyers. Another thing good lawyers do is read the briefs, right? You find an important case, you go look at the docket, you pull the briefs, you see what happened. You can do that at the Supreme Court, you can listen to the argument. You can do it at the federal circuit, there will be redacted briefs. You can listen to the argument. GAO, the boards, there is no docket, you can't read the briefs. We have a docket at the Court of Federal Claims, but redactions are not always available. And so it limits our ability to really dig in and learn from the other lawyers litigating these issues. So I'm going to stop my rant and open it up for discussion.
I thank you, Nathan. And just to amplify Nathan's point, he's pointed, as we prepare for this webinar over the last few weeks, he's emphasized again and again how important it is that we as lawyers and as professors understand rules and principles, tools of statutory construction, because those tools we apply both to statutes and probably regulations under the Loper Bright as a threshold matter, trying to make sense of what Congress or the agency meant. Before we turn to these other potential points of change, we did have a question overall, which was, how will this Loper Bright Enterprises decision affect line personnel? And the answer is really hard to tell, because it's difficult to see where the courts will go exactly with this. There's likely to be, and we no longer use the word deference, there's likely to be respect to the agencies that are under the FAR. So there's going to be respect to the FAR. That's pretty well developed in our law, as Nicole pointed out. But it's very possible, as we'll discuss in just a second, that the agencies are going to be less activist, less aggressive in terms of the rulemaking, because they'll be afraid of a possible attack under Loper Bright, where the courts will say, no, you don't get to decide what the law is. We get to decide what the law is. That's what the function of the courts is. Joshua, I know, had a point to pick up on what Nicole and Nathan been talking about. And also, Joshua, if you could also just talk briefly about whether or not now, after Loper Bright, we're in a Skidmore world or in a Kaiser world. Joshua?
Sure. Second first, the court says we're in a Skidmore world. It says it very explicitly. It says it 3 times. You know, my colleagues, administrative law professors, don't necessarily believe that. And there's some of them that says Skidmore has 2 consecutive sentences. They only quote the one. So, you know, is consistency, longstandingness, remains to be seen. But they say they're doing Skidmore, and they don't say a word about Kaiser, though a lot of people propose that. So I think silence about Kaiser and invoking Skidmore is what was intended. The other thing I wanted to do was underscore what Nathan said about lawyers needing to be careful about where particular delegations come from. This could not be more true. I want to just briefly illustrate. If you think about the cases that Nicole brought, they are cases that actually had express delegations in them. Nathan also made that point. But it's also true that the old cases were just careless about whether it was a general express or an implicit delegation. Judge Bryson, who's an old friend and the best lawyer I know in this world, when he says this is a Chevron deference case, he's just wrong. There's a specific delegation there. And so you don't need Chevron, but no one cared about that in the old regime. And so there are a lot of old cases that cite Chevron, where now what careful lawyers are going to do, if they're on one side or on the other, is to go back and say, does this depend on Chevron? And you might come up with a yes, you might come up with a no, you might come up with an argument for the court. But that's what it's going to be about. And Nathan's advice couldn't be better taken on those points. Enormously important.
Thank you very much, Joshua. And I want to go back to the specific examples here on the slide, and with the audience's indulgence, because we do have a lot to cover, and we also have a couple of questions pending. If we could just talk a little bit about these points and then go to 10:15. I apologize for going a little over time. Nathan, what's your view on there's a final rule was issued with regards to green procurement requirements. Agencies are supposed to make the maximum possible use of green procurement using eco labels. That's a finalized rule. There is a pending rule back from November, I think it's November 2023. The pending rule says that that contractors that are significant contractors are required to chronicle their greenhouse gas emissions and report those. Really, if they don't, they could be found non-responsible. It's a first step to eventually bringing greenhouse gas emissions into a technical assessment that the greener contractor would get the contract. But that's been derailed by the National Defense Authorization Act, which last year's National Defense Authorization Act said the Defense Department is not allowed to ask for that information permanently from the non-traditional contractors, and from traditional contractors is held up for a year. So there's a stutter step here. How do you think Loper Bright Enterprises will affect that pending rule, that green procurement rule, Nathan?
I'm not sure that I think this whether Loper Bright actually impacts it will sort of depend on what's left of the major questions doctrine. And I'm not sure what cases are going to be cited, right? I think it's a little bit of an open question now. I imagine the briefs will hit Loper Bright and the major questions doctrine. I think either way, as a broad regulatory scheme, that's just going to be hard to pull off without some sort of statutory authorization.
You talked about cost accounting. I want to just talk quickly. And Joshua and I have discussed this over the years. Joshua, how do you think Loper Bright will affect the FAR rulemaking process itself? One of the quirks of a FAR rulemaking process is that it's very common for Congress to pass that's a statute. It's really typically part of Title 8 of the National Defense Authorization Act, saying we want the FAR Council within 180 days to publish regulations on X. And then the FAR Council doesn't do that. It may delay for years sometimes in delaying it, in issuing that regulation that Congress has called for. How do you think Loper Bright will affect that quirk in government contracting law, where the agency take the position, look, it's not on the FAR, and yet there's a statute that says publish a rule that says X. X is not on the FAR yet, so agencies, contracting officials say we don't have to follow it. How do you think Loper Bright will affect that, Joshua?
I mean, very hard to know. The court's opinion does read like they know this is sort of constitutional in breadth. I don't mean it's con law. I just mean this affects 1,000 statutes, more than 1,000 actually, and 150 agencies. And we have to get this right for everybody, and we can't possibly do that. So you all know how Congress has a process of legislative corrections for major bills. It's as though the Supreme Court needs a process like that, but they don't have one. They actually do, correct typos and things like that. But we're going to have a case-by-case process, which I think Nathan and Nicole have already hinted at, that will eventually bring this down to earth. And it's going to be, what do lawyers hate? Lawyers hate uncertainty. I mean, some people's clients are actually benefited by it, but lawyers in general hate not being able to know. And I think you're going to have to tell your clients that you don't really know, that the court didn't figure these things out. So on the one, the best analogy I've got, and we discussed this in one of our planning meetings, is the international law situation. Some of our audience will know more about this than I do. But you have treaties which are self-implementing and treaties that are not self-implementing. So when you have a statute that tells the FAR Council to make a regulation and they haven't done it, it's pretty clear that that wasn't meant to be self-implementing. But, in international law contexts, that'll sometimes get litigated. If there's a clear prohibition, don't do genocide, even though somebody's going to implement that, maybe the preliminary proposition, the basic underlying proposition, is already the law. So that's going to get litigated case by case. I think Loper Bright contributes 0 degrees of clarity to that analysis. I think it'll just be a thing to fight about, and there'll be more attention to fighting about it, but I don't expect this is helpful. I think more generally, looking at your list, there are a lot of statutes that make delegations here. They're generally not Chevron dependent. So Nathan also said this, I think major questions is going to be a bigger issue going forward. Green procurement will be a major questions issue because they'll say Congress wasn't thinking about green procurement because they couldn't have been in 1940, whatever, because nobody heard of it. So that makes it a major question. One of the best administrative law people I know, Dan Farber, has written in the last couple of days in the administrative law blog, the problem with the major questions doctrine is that nobody has yet said, here's the thing to which the major questions doctrine doesn't apply. It's like, it's as elastic as hell. And it causes the judiciary and our law to be in bad repute because it looks like judges can do whatever the hell they want. And that's not what I think the rule of law is. For what it's worth, I don't think Justice Scalia thought that was what the rule of law is. I don't think he'd be happy with all this stuff. He and I don't agree, but I don't think he'd be happy with this.
On the Buy American issue, the regulations that have come out of the Infrastructure Act, in some ways, the Buy American definitions, for example, of construction materials, that conflicts with the regulations under the traditional Buy American Act. So that there's a lot of mishmash in the most recent Buy American regulations, and questions how Loper Bright Enterprises make sense of that. I did want to talk about just quickly about bid protests. And Nicole and Nathan, you regularly handle bid protests. How do you think Loper Bright will affect bid protests?
I don't think Loper Bright's going to really affect protests, except to the extent that protests can be the mechanism to bring some pretty unique challenges, and they may end up being the vehicle that regulations are challenged, like to the extent, kingdomware. I think you might have more cases like that that work out a little smoother because of Loper Bright, but I'm not sure that on a day one basis, protest practice is going to be impacted by Loper Bright. You just might have certain bid protest arguments used as the vehicle to challenge an agency's interpretation of a statute.
Nicole and Nathaniel, we got a question from Hillary Erickson that said, Nicole did an excellent job presenting case law in which the FAR's ability to provide specificity has been upheld, such as who may certify a claim. Is there any case law or examples where agency supplements to the FAR have similarly upheld? The only example I can think of offhand is the case you talked about, which was the case regarding the vending machines. That there was DoD guidance that was really, and DoD didn't have primary authority. HEW had primary authority, and yet the Federal Circuit deferred to that DoD guidance. And are there any other cases that you can think of?
Yeah, and I'm not sure if I heard the last part of the question there.
Is there any case law or examples where agency supplements to the FAR have been similarly upheld?
That's a good question. I can't think of one off the top of my head. Not that came up immediately.
Yeah. I want to turn quickly to the corner post question before we close out. The corner post decision was issued in the same slew of decisions at the end of the term, and the Supreme Court there said that a party challenging a rule under the APA can really doesn't have to bring that challenge until it's actually injured. And so the normal six, as Justice Jackson pointed out in her dissent, the normal 6-year statute of limitations could basically be eviscerated, be erased, because the party doesn't have to bring a challenge to a regulation within 6 years. It's when they're first injured, which could be 20, 30, 40 years later. So really, corner post really opens up this issue of statute of limitations. Joshua, am I reading corner post correctly?
Well, first of all, you are, though I'll try to make it worse. The consensus among the administrative law scholars is that corner post is far more damaging to the administrative state than Loper Bright. Second, the reason that that's true is, although one could have a good faith late claim, I wasn't born yet when this rule was implemented, so how could I have brought it 27 years ago? It's also totally manipulable, and unless some standards are written, it's hard to see how that'll be. So your General Motors, you create a new subsidiary, and then as a matter of corporate law, they can bring the claim, even though General Motors has been around for 100 years. You're a trade association, and you have a claim that you're bringing on behalf of members, which you can do under applicable standing law. You have new members or newly born members. Any claim can be brought at any time. And seriously, if taken to its logical extreme, the degree to which opponents can challenge everything is literally multiplied 100-fold or 1,000-fold. It could just bring the system to its knees. The suggestion is they'll say, oh, we didn't really mean that. But exactly what they did mean is not clear. So corner post is quite damaging. Good faith is, you have a regulation, and I'm now a brand newly incorporated entity, and I do solar panels, and your regulation was made in 1947, and I didn't exist then, and I wasn't born then, and I'm bringing it in good faith as soon as I see that it affects me. But it doesn't sound like a good or feasible idea to say courts see whether they have a good reason for bringing it tardily. A good reason. So this could be a big problem. On the other hand, this is like the Lawyers Employment Act of 2024. You put Loper Bright together with corner post, and you get someone who's willing to invest in your lawsuit, and you're off to the races.
Nathan?
If I want to just add a few points on this. I think it carries a lot of the themes we've discussed with Loper Bright. Corner post is a very important case for government contracts lawyers, and if it weren't for Loper Bright, we wouldn't be talking about it. Like, this is just an example of the kind of case that comes out every year that matters, that we might let slip past as a procurement community that we need to be watching. This is another one also where, I mean, they are interpreting a specific statute of limitations. They're drawing inferences from other general principles of statute of limitations, but you really have to be careful of making sure you know which statute of limitations you're talking about, because we deal with a lot of different statutes interpretations. The Tucker Act has its own that's very special. The Contract Disputes Act has its own that's special. So corner posts might be informative, but you do have to always keep track of the unique statutory strands. And the other point here is, even if it is a blow to the statute of limitations and it creates some wishy-washiness, we also deal with that in the protest space with waiver rules. You've got blue and gold and these rules that are meant to help agencies avoid certain protests. If those rules don't stop a protest on the front end, you always, when you get to the equitable factors, get to ask, was this unreasonably delayed? And I think that, we always sort of, when you get to the point of equitable relief, there's always a little bit of a judge saying, hey, was there something nefarious in this delay, or could you have come sooner? Or would it be unfair to enjoin this rule 10 years after the fact? I think there is room in the law to deal with that.
We got a question from Chadwick Stevens. How might Loper Bright impact state government procurement policies and contracting decisions, and when might we see those impacts? I think that so many state, for example, many state bid protests are run under a state level APA, Administrative Procedure Act, and so you'll see a parallel there between the federal APA and the state APA. Now, one of the reasons to bring up Percipient.ai was to show, at least my perspective is, it really illustrates that this is not a political thing in the federal procurement space. In the federal procurement space, it's not a liberal versus conservative thing. It's a question of whether or not the courts are going to be forward-leaning in terms of how they interpret the law. But at the state level, where the very major bid protests will go on a very rapid basis, and the courts will be very rapidly involved at the state level. I think it's very possible that state courts, especially conservative state courts, when they have to make those decisions quickly, will look to the parallel decision of the APA and the Supreme Court, and will be more willing to be aggressive in their reading of the law, to take first authority over questions of law in those state level bid protests. That would be my guess based on my own experience. Do y'all have any other observations on that? Very good. So I did want to close out with a really nice comment that we got from John Pachter. John Pachter said, "Wonderful webinar. Thanks to all. Special nod to Joshua Schwartz, who has this stuff in his bones." That is a perfect way of putting it. Thank you all. Thank you all. Any final comments from you guys? All right, great. Thanks very much to the audience, and have a great day. Take care. Bye-bye.